Good morning, ladies and gentlemen, and welcome to the second day of oral argument for the Eastern Section of the Tennessee Court of Criminal Appeals here in Knoxville. My name is Robert Montgomery. I'm going to be the presiding judge today. I'm from Sullivan County. To my right is Tom Greenholtz, who is from Hamilton County. To my left is Kyle Hickson, who is from Knox County. Now today we do have, which one is it? It's not the second case. Okay. All right. Generally speaking, each side has 20 minutes. And if you're the appellant and wish to reserve some time for rebuttal, please let us know before you begin your argument. We have a timer and the lights on the podium, so that'll be calculated for you as we proceed. All right. Now, Madam Clerk, are there any preliminary matters today? Yes. All right. You want to call the first case then, please?
State of Tennessee versus Ross.
Good morning.
Good morning. Brennan Wingirter with the Public Defender's Appellate Division here on behalf of Mr. Ross. May I reserve 4 minutes for rebuttal, please? Thank you. Your Honors, this case is about the legislature's power and authority to establish sentencing laws and procedures in Tennessee, and the trial courts and appellate courts' duty to follow those laws and procedures. In this case, the trial court sentenced Mr. Ross to a felony conviction without receiving a validated risk and needs assessment, which is often called a strong R assessment. We are asking this court to reverse and remand for a new sentencing hearing after the trial court has considered that mandatory component of Tennessee sentencing law.
So, counsel, let me ask this. So you start off the argument by suggesting that it's a question about the power of the legislature. Isn't it really about the power of the appellate courts to consider errors that were not properly preserved in the trial court? So that's not really a legislative issue. The law is the law. I think the issue here is whether it was properly preserved so that we may review it.
I think it's both.
Okay.
So to address the waiver argument first, this court, a panel of this court in Pace, recently concluded that the lack of a pre-sentence report with a validated risk and needs assessment can be waived for failure to object to the lack of those documents during the sentencing hearing. Number one, that's an unpublished decision. Rule 11 application is currently pending. But perhaps most importantly, that decision, like the Ailey decision, which is also unpublished that the state relies on, both Pace and Ailey rely on a case, State v. Gilley, for the proposition that you can waive the preparation of a pre-sentence report by not objecting during a sentencing hearing. They both cite Gilley, which is published from 2008. But Gilley was about a trial evidentiary objection. We all know if you don't contemporaneously object to witnesses' testimony as hearsay during trial, which was the issue in Gilley, that's then waived on appeal. Gilley had nothing to do with sentencing. The Tennessee Supreme Court, this court, for years have said the two things you cannot waive are sufficiency and sentencing. That has not changed. The only thing that has changed is...
I mean, you can waive those, but I mean, typically when that waiver statement is made in the context of failing to raise an issue in a motion for new trial or failing to file a motion for new trial. I mean, sentencing issues can be waived by failing to object at the sentencing hearing, right? Introduction of evidence at a sentencing hearing, things like that. Those objections can be waived on appeal, right?
An evidentiary objection, I think, would be closer to the situation in Gilley, correct? But we don't have the Tennessee Supreme Court saying, at least as of now, that you can just outright waive a mandatory component of the sentencing laws by not objecting to the lack of that pre-sentence report. The only thing that I've seen is out of this court, Pace and Ailey, and then also out of this court, several unpublished decisions saying that you can waive offender classification by not objecting to your offender classification range 1, 2, or 3 in the trial court. That has not yet been addressed by the Supreme Court either. So what we have from the Supreme Court is you can't waive sentencing issues. What we have from the General Assembly is trial court, you shall consider pre-sentence report, validated risk and needs assessment, among many other things. And then we have the Court of Criminal Appeals in Pace and in 2019 in Ailey saying, well, you can waive those by not objecting at the sentencing hearing, and our only authority for that is Gilley, which had nothing to do with a sentencing issue.
Not the only authority, right? I mean, isn't other authority Rule 36B that says that you can't raise an issue on appeal unless it's been first addressed in the trial court, right?
That's correct, Your Honor, but I think all of those issues are, in motions for a new trial, we're always talking about what happened at the trial court level for the trial court to fix. In sentencing, and specifically, I want to narrow it even more to this sentencing issue. This is a statutorily mandated component of sentencing procedure. And the Marshall case, which admittedly is also unpublished, but Marshall is what the state argued originally in Pace and in Anderson, another unpublished case. The state originally argued that in Marshall, this court said, you cannot waive the preparation of a pre-sentence report because they are required for a trial court to apply the purposes and principles of sentencing, and they are necessary for appellate review. Marshall, it did not say explicitly, you cannot waive it. But implicitly in Marshall, the parties had waived the preparation of a pre-sentence report at the trial court level. And it got up on appeal, and this court said, trial court, you can't do that. We're sending it back. So at least implicitly, the court in Marshall said you cannot waive this mandatory component of sentencing, because without the mandatory components, to get back to the legislative side of it, the legislature has said you shall consider these things. You shall include these things. You must consider. We'll give you discretion on how you weigh them, sure, but you have to consider them in the first place. That is still in place by statute.
Let's assume
Okay.
that, I'm sorry, go ahead, please.
Well, okay, I'm a little bit, all right, if you look at 4035-207, which is the definition of a pre-sentence report, the first part says the pre-sentence report shall set forth, and then there's 10 things. So is your argument that if the report doesn't have 3, information relating to enhancing or mitigating factors asserted by the parties in its source, then it's an invalid pre-sentence report and you have to send it back?
Yes. Our position.
So none of there's no hierarchy on any of these 10. So if any one of those 10 is not in the pre-sentence report, then it's your contention that you have to send it back and do it.
Correct, because our position is shall means shall.
I understand.
The
I understand.
legislature,
I'm just making sure that
Yes, Your Honor.
you're not elevating the risk and needs assessment to a higher level
No,
than some
no,
of these other things.
no,
You're saying,
not at all. What the
And
legislature,
the position actually goes a little further than that, than what Judge Montgomery is saying, because I think your position would be that the other information in the pre-sentence investigation report, if it's absent, the defendant doesn't even need to raise that issue with the trial court to then preserve it on appeal, right? The defendant can sit back, see what the sentence is going to be. If the defendant's unhappy with the sentence, then we have an automatic appellate issue. Is that the extension of the argument?
I don't intend it to seem like the sort of gamesmanship that I understand the court would be concerned about. My point is that the legislature has mandated by statute, and the trial court has an independent statutory duty to ensure that the Department of Correction provides the required information. We can't.
of course, they don't have it. They're not the court's employees.
But what's interesting is that by statute, it is the trial judge that orders the preparation of the pre-sentence report. Sure. So if we take this all the way through, if we had objected, or if a defendant objects at a sentencing hearing and says, Your Honor, number 3 in the list is missing from this pre-sentence report, and the judge says, oh, I don't need that, that's okay. We'd be making the same argument on appeal, because we don't have the ability to go and force a pre-sentence service officer to conduct that investigation.
You would have a better argument on appeal because you had objected at that point.
We certainly would not have the waiver hurdle. I agree with that. But substantively, the argument would be the same. We would still have a sentence that was conducted without all of the statutorily required information. And the question would simply be, did the trial court have that information or not? Was the trial court required to have that information or not?
Well, and of course, again, I think there are probably things on this list that a defendant may not necessarily want the judge to know about. So, because the state also has a right of appeal, when the case goes up, would your contention also be then that the state would have a right to say, Judge, we need to do a resentence because the pre-sentence report didn't contain all of his prior convictions? And as a result, he got a lower sentence than probably what he was entitled to. Would you agree that that's the logical?
I agree. That is the logical continuation. And I think that's actually part of the problem for the state in this case, because part of our argument, if you get to the facts of this case, are that The victim impact statement was never included. That is one of the things that is required to be included in a pre-sentence report. The original report said it would be added as an addendum. It was not. The victim statement was not made an exhibit at the sentencing hearing, and so our position is the trial judge relied on information outside of the record and made an erroneous assessment of the proof when he mentioned some things from the victim. It's not in the pre-sentence report. And there are other things in the list of shall that, like the prior convictions, that, again, it's not, I suppose our position is not necessarily that the pre-sentence report is supposed to favor the defense or favor the state. It is supposed to fully inform a trial judge on the most fair, appropriate sentence for both parties, for the public.
And looking at your client's past history, not so necessarily objectively, I'm not so sure risk and needs assessment would be helpful to you.
The state made that point too, Your Honor, and respectfully, I disagree.
And I'm not parroting the state. I'm just saying, objectively looking at it, I'm not necessarily.
Let me follow up on that before you answer, because I think Judge Montgomery raises an important issue. So in the reply brief, you don't concede that plain error is the standard under which we go, and you're not doing that. But if you were to assume that we are under plain error, so the fifth factor under plain error is whether correction of the error is necessary to accomplish substantial justice. What we have here is we're maybe speculating about what the risk and needs assessment would contain. Under plain error, where you have the burden to show that correction of the error is necessary to substantial justice, we don't know what the risk and needs assessment is or what it would reveal. Silent. How do we find that the correction of the error is necessary to do substantial justice?
I think in this case, it is similarly based on, those are two sort of related things, I think. So we have someone who has a history of prior convictions. We acknowledge that. He also has a history of severe drug abuse. In the pre-sentence report, he personally reported that he, at 28 years old, had overdosed approximately 9 times in his life. This is a serious drug addiction problem for this young man. What a strong R is supposed to do is to assess whether his criminal behavior might be lessened if his underlying needs are addressed. And clearly, in this record, he has underlying social, educational, substance use issues that have not yet been properly addressed.
But that's only one part of it. So it's a risk and needs assessment. And so the needs assessment does do that. The needs assessment identifies what areas would be critical areas for addressing needs, and what resources can be brought together for that. But the separate part of it is also a risk assessment. And that risk assessment compares the defendant to a group of other defendants with like characteristics and then tries to predict as a group how likely they are to reoffend. And what I hear you telling me is that we have a history of criminal behavior. We have substance use, maybe significant substance use, that if left untreated probably would increase the risk score. If a risk and needs assessment came back for high for drug use, heaven forbid it came back for high for violent conduct, correction of the error under plain error review would not be necessary at that point to do substantial justice, would it?
It would still be necessary to do substantial justice in the sense that the trial court would then have all of the information that it is statutorily required to consider before deciding the appropriate sentence.
But it wouldn't affect the outcome of the sentence, and I think that's what plain error.
In this particular case, it may not. But
that's what you have to show under plain error, though, right?
But not necessarily. I don't think we necessarily have to show that in this case the outcome would be different. The standard is whether is reversal is necessary to do substantial justice. Our position is, one, this is a defendant who, because he was eligible for probation, and he did have significant substance abuse issues, that a validated risk and needs assessment, under its own statutory definition, directly targets the issues that we're talking about with this individual person. But on a broader scale, we're talking about the substantial justice to the entire sentencing procedure. We are talking about a statutorily mandated component of sentencing that simply was not done, that the state previously acknowledged, agreed that the purposes and principles of sentencing, which are still mandatory after buys, can't be done properly if the trial court does not have all of these statutory components. That's the harm that is done to our system and our position. And I'll give an example of when it might not be required to do substantial justice would be if the person was not eligible for alternative sentencing. What would a risk and needs assessment add then? I'd have to concede probably nothing, right? Because alternative sentencing wasn't an option for the judge. But here it was. And so whether the ultimate outcome changes or not, the process is not true to the legislative mandates that the trial court shall receive and consider the pre-sentence report, which at least one part of it is this validated risk and needs assessment, which is particularly important in a case like this where we have evidence of substance abuse driving the criminal behavior.
Recollection. At the time he was sentenced, this is 75%,
Yes, Your Honor.
but you were eligible for alternative sentencing.
Correct.
Now it's 100%.
I believe
and you're not
right.
eligible
It was
for-
75% at the time.
And you could earn up to 15% reduction.
Correct.
Now I think it's 100%. You have to serve it.
I'm not 100% sure, but it may be. And I think that adds to our argument. I mean, we have our sentences in Tennessee are only getting longer. The release
Some would say that if the legislature says you ought to serve 75%, that the crime's so bad that arguably the odds of doing well on alternative sentencing is not good.
But that is up to the trial court
Sure.
being fully informed. And I think that's our position.
And all I meant was that 75% can cut both ways.
Sure.
What it means, the meaning of it.
Yes, Your Honor. And I think, again, the trial court is entrusted to make that decision if it has reviewed all of the statutorily mandated information. And that is the problem that we have here. Waiver or not, we have a trial judge sentencing someone to 9 years of incarceration when, if we had had the mandatory components of sentencing, may very well have considered at least split confinement for this young man. And we would ask this court to reverse. Thank you.
Thank you. General?
May it please the court. I'm Alicia Gilbert on behalf of the state of Tennessee. This court should affirm for two reasons. First, the missing strong R assessment from the pre-sentence report is waivable. Because defendant never objected to this issue at his sentencing hearing, he's waived this issue on appeal. And he has not shown that he's entitled to plain error relief. Second, the trial court acted within its discretion when it imposed a within-range sentence of confinement. In Pace and Ailey, this court held that a defendant waives his ability to challenge a missing strong R assessment when he does not object to this issue at his sentencing hearing.
So let me ask you, General, here. I mean, we're talking about waiver as if this is somehow a right that's personal to the defendant. And so, typically when we're thinking of waiver issues, otherwise maybe evidentiary issues, maybe something else, sentencing is qualitatively different. So, as your friend on the other side has said, the legislature has mandated trial courts consider certain information. Sure, the trial court could reach a proper sentence under the laws it currently stands without a risk and needs assessment. But the right to have a risk and needs assessment is not something that is personal to the defendant. It is actually part and parcel of the sentencing process that the trial court must go through. If that view of sentencing is correct, I don't know that it is, but if that view of sentencing is correct, how can it possibly be waivable? So Ailey says that it is, but it's relying upon older authority. It's also relying upon Rule 36. Ailey doesn't have analysis that is substantially, Pace doesn't have analysis that's substantially different from Ailey, and Pace is before the Supreme Court right now. Isn't this fundamentally a different issue when the trial court itself is not complying with its statutory duties as required by the legislature?
No, Your Honor. As Your Honor recognized, there is a distinction in the case where there are components that touch on the sentencing issue, such as the introduction of evidence. And so it's the state's position that this court was correct in finding that that the strong R assessment was waivable.
Could a defendant waive a psychosexual evaluation in a sex case?
I don't think so, Your Honor.
Of course not, right, because it's a required component. Could the defendant waive presentation and consideration of the pre-sentence report as a whole?
No, Your Honor.
No, of course not. But it's not because those are rights that are personal to the defendant, but those are things that the trial court must have to reach a just sentence in compliance with the statute. And so if the risk and needs assessment here, which was passed as part of the Public Safety Act, 2017, is a fundamental component of that and is actually a listed consideration, must be part of the pre-sentence investigation report, itself cannot be waived. How is this waivable by the defendant in the first instance?
I think an important distinction is while it is listed as a component of the pre-sentence report, the trial court is not required to give any particular weight or any weight at all to the strong R assessment. So in other words, the trial court could have the strong R assessment there and essentially ignore it in issuing its sentencing decision. So
there are other aspects of sentencing where that occurs as well. So merely because a trial court finds that enhancement factors, for example, apply in a case, trial court's not required to give any weight to those. Even though a trial court finds that mitigating factors may also be present in a case, the trial court's not required to give particular weight to those either. But I think both you and I would agree that a trial court cannot conduct a sentencing without considering enhancement mitigating factors, right? The defendant can't waive that.
I think another important distinction is that there are components that the trial court did have access to that touches on the same information that the strong R assessment assesses. There is information about the defendant's criminal history, about his social history, his drug abuse history, his past failures at probation. In other words, the trial court still has access to the information in making its sentencing decision that the strong R assessment would have. It just does not produce the quantitative score. And I think it's important that the trial court need not afford any particular weight or weight at all to the strong R assessment, which is what distinguishes it from some of the situations that Your Honor has identified.
Then why would we need a strong R assessment in any case?
It is true that the legislature has included it as a component, but
It's the law.
that's right.
So if we accept your argument that we don't really need it in this case because the trial court had all of the information that would have been in the strong R, doesn't that argument, if extended, just render a legislative enactment a dead letter?
I don't think so, Your Honor. The state recognizes that it is a component of the pre-sentence report that is required, but again, the state thinks that it's an important distinction that the trial court need not rely on the strong R assessment in making its sentencing decision, and that's the case in any sentencing decision that the trial court
But the
makes.
assessment is qualitatively different from the information that gives rise to the assessment. So as I was discussing with your friend, it has two components to it. So one of the component is an actual score, as you say, that will rank a defendant in comparison to a group of others. And you may be at a low risk to reoffend, a medium risk to reoffend, or within several categories of high risk to reoffend. What's important here, though, is the background. So the risk and needs assessment was adopted as part of the Public Safety Act. As part of the Public Safety Act, there was a renewed consideration of the use of rehabilitation in sentencing. Part of what the risk and needs assessment was trying to do was to identify particular needs and then to identify particular ways that we could go about addressing those needs in the context of a supervised probation sentence or other monitoring. And so merely because the trial court had a view of prior criminal history, maybe of substance use otherwise, it did not have the information that's included as part of the needs assessment to inform the court about how we could go about remediating those conditions. That's the important part of the risk and needs assessment. Once again, I think I'm trying to ask, but let me ask a different way because I'm not asking it clearly. That doesn't seem to me to be a right of the defendant that the defendant can waive, but is a mandatory consideration that the trial court must consider when we're talking about the length of the sentence, but also the manner in which it's to be served. So how can it be waived by the defendant?
Again, this court has found in Pace and Ailey that this exact same issue is a waivable issue. And so the issue today is what's appropriate for this court to review on appeal.
Why should we give those cases stare decisis effect? They're unpublished. They may be based upon inadequate reasoning. They may not be fully taking into account the background, reason for the risk and needs assessment by virtue of the Public Safety Act. The analysis in both Ailey and Pace is not extensive. Both in Ailey and Pace, it's about one paragraph. Pace itself relies almost exclusively on Ailey for that. Why should we give them any stare decisis effect at all?
Because at the sentencing hearing, defendant would have had an opportunity to object to the missing strong R assessment, and he failed to do so. And as this court has recognized, it's not on appeal. This court can't review an issue that was not first raised at trial. And so Pace and Ailey, which both decided the exact same issue that's before this court today, have found that this issue is waivable. And in Ailey, the strong R assessment could have conceivably been helpful to that defendant because he didn't have a criminal history. He was described as a successful businessman, and he was well respected and very active in his community. Nevertheless, the court found that the issue was waived because that defendant did not first object to the issue at his sentencing hearing.
Was there consideration of plain error relief in Ailey?
Pardon, Your Honor?
Was there consideration of plain error relief in Ailey? I don't remember
No,
seeing it.
Your Honor, I
So
don't.
we don't know that there was a plain error issue. That's an issue that you have here.
Yes, Your Honor. I misspoke. In Ailey, well, no, it was in Pace that asked for supplemental briefing as to plain error.
So when you say that it can't be considered, all that really can't be considered if it's not objected to in the lower court is plenary review. There still is a theoretical possibility of plain error review. Your friend requests plain error. So how does this not fit within plain error?
So defendant is not entitled to plain error review for two independent reasons. First, defendant did not raise plain error review or relief at all in his principal brief, and even in his reply brief, he fails to establish that he's entitled to plain error relief. As this court is aware, defendant has not met his burden to show plain error relief if any one of the elements hasn't been established. And the easiest way for this court to resolve this issue is to find that defendant hasn't shown that consideration of the error is necessary to do substantial justice, which is what this court held in Pace.
Why not? Why do you believe the fifth factor isn't met?
The Pace panel reasoned that because the strong R assessment doesn't have to be afforded any particular way or any way at all in sentencing, it would be difficult for a defendant to show that the lack of the strong R assessment was necessary to do substantial justice when a trial court could have essentially all but ignored that strong R assessment in making its sentencing decision. But here, I believe the defendant has also failed to show that a substantial right has been adversely affected. For one, the provision instructing the trial court to consider the strong R assessment is not constitutional in nature. It's a purely statutory sentencing provision. And for two, defendant hasn't demonstrated that the missing strong R assessment has prejudiced him. And this is something that the defendant is required to do, is to show that it prejudices him individually.
But as I'm hearing the appellant here, I think she didn't use this language, and I don't want to put words in her mouth. She's asking us to presume prejudice on that point, as I understand it, because the defendant was subjected to a sentencing hearing where the trial court did not consider everything that he was statutorily required to do. So if that is in fact what the appellant is saying, how do you respond to that?
Again, the other components of the sentencing report were present, and the court is able to rely on those components in making an assessment as to whether alternative sentencing is appropriate. There is not any weight at all that has to be afforded to the strong R assessment. And in Pace, this court found that just relying on the lack of the strong R assessment alone would be inviting the court to elevate form over function. And as the defendant acknowledges on page 12 of his reply brief, he has a history of criminal history. There's ample proof of his criminal history and his past failures at probation. The strong R assessment, which quantifies this same information, likely would have only further solidified the trial court's sentencing decision. So this court should decline defendant's invitation here to, again, elevate form over function.
So basically what you're saying, and correct me if I'm wrong, is that this sentencing hearing was good enough. It didn't have everything that the statute required, but it was good enough and it gave the trial court enough information that it needed to make an informed decision. Is that what I'm hearing?
Yes, Your Honor. There was enough information there to where defendant was sentenced in accordance with the purposes and principles of the sentencing act.
That cannot be true, right? Because one of the key pieces of information to be able to form a sentence that complies with the purposes of
The trial court had information related to defendant's criminal history. He had information related to his past failures at probation. He had evidence related to enhancement and mitigating factors. He had every component of the pre-sentence report aside from the strong R assessment. And it's not the case here that the strong R assessment likely would have helped the defendant. It likely would have shown that this defendant had a high risk of reoffending.
How do we know that? I mean, respectfully, that seems like speculation. I mean, my experience as a trial court judge, I would take a look at the risk and needs assessment, and the risk assessment in some cases would come back as moderate, and I thought it would top out the chart. I mean, we don't know, in point of fact, what the risk assessment would have been. Is that fair?
That is fair, Your Honor.
Okay.
But I think it's important also to recognize that defendant had an opportunity to object to the missing strong R assessment at his sentencing hearing and failed to do so. So part of the reason of why we're having to speculate in this case is because we simply don't have information to see what the outcome of the strong R assessment would have been. And at this juncture, it would be defendant's burden to demonstrate that the strong R assessment would have been helpful to him and would have affected the trial court's sentencing decision.
But General, we've established here today, I believe, that previously there had been a couple bright line rules in this area. We've talked about how you cannot waive a pre-sentence report entirely. You cannot waive a psychosexual evaluation. We accept the state's argument here that you can waive a strong R assessment. Doesn't that put this court and other courts in an unenviable position of making qualitative determinations about what is good enough in any given sentencing hearing? And if we do that, doesn't it denigrate strong R assessments to kind of a lesser status than the other statutory provisions, which are also mandatory?
No, Your Honor. I would like to first point out that the cases that defendant relies on that touches on the complete lack of the pre-sentence report does not address waiver at all. In those cases, there was simply a remanding for a new pre-sentence or a new sentencing hearing and for the pre-sentence report to be prepared. So there's nothing, there's no precedent that currently says that the lack of a pre-sentence report altogether is not waivable. That said, I think there is a very important distinction when there is a complete lack of the pre-sentence report altogether. And the state has conceded in that situation before that remand would be appropriate. But here, the only component that's missing from the pre-sentence report is the strong R assessment. And that assessment, again, is not required to be afforded any way at all.
But it is mandatory. I mean, isn't that almost like saying that the only part missing from the airplane was the wing?
No, Your Honor. I think it's an important distinction because here the trial court still has evidence related to enhancement and mitigating factors. It still has evidence related to his criminal history, his social history, his drug use history. And
that gets me back to the point, what's the point of a strong R assessment then? If it's just going to parrot back what has already been provided to the court in other areas of the pre-sentence investigation, why do we have it? And setting aside the point that it's the law, and doesn't that really speak to Judge Greenholz's point that it doesn't necessarily parrot back what other information was included in the PSI? It hits on other areas and may in fact yield different results than what you might expect having read the rest of the pre-sentence investigation.
The strong R assessment is a tool that helps the trial court determine whether defendant is an appropriate candidate for alternative sentencing. But here we have the trial court relying on information in the record. He relied on all three confinement factors, whether confinement was necessary to protect defendant with a long history of criminal conduct, and he pointed out defendant's prior criminal history, whether confinement was necessary to avoid depreciating the seriousness of the offense or to provide an effective deterrence. And he relied on this confinement factor, finding that the offense was serious and that there was a need for deterrence in the community, or whether measures less restrictive than confinement have frequently or recently been applied unsuccessfully to the defendant. And here there were past failures at probation. Those were the appropriate factors for the trial court to look at in determining that confinement.
But to get to those factors, though, the statute requires consideration of particular pieces of information so that you can arrive at those conclusions. That, for example, that you would be unlikely to be successful on probation again. That's the very point that the needs assessment is meant to address. So I keep hearing the state, I keep hearing the argument that it's okay not to have it in this case because the trial court doesn't have to give particular weight to the risk and needs assessment. That's true with respect to almost every aspect of sentencing. So as a trial court judge, I have to consider the statistics from the administrative office of the courts. I don't have to give any particular weight to those. In fact, depending on the standard deviation, they may have no weight in a particular case. Once again, with enhancement factors, I must consider enhancement factors and mitigating factors, but I'm not required to give any weight to any of those. In almost every aspect of sentencing that there's information that I have to consider, but I don't have to attribute particular weight to almost anything. And so if that's the case with respect to all of sentencing, then how can that really be the case that the defendant can waive it here simply because the trial court doesn't have to give it particular?
Well, at this juncture, defendant has to show that the strong R assessment would have impacted the sentencing decision. And I think here the strong R assessment was likely to show that he would have a high risk of reoffending. And the trial court had, again, the rest of the information which was required in the pre-sentence report and isn't required to give any weight at all to the strong R assessment. So far from showing that the strong R assessment would have even affected the outcome of the sentencing decision, the strong R assessment, while it is a component of the pre-sentence report, doesn't have any weight associated with it that the trial court has to rely on or give to it. And I believe those are the reasons that this court has found that this very issue is waivable in Pace and Ailey. And while those are unpublished decisions, they're the exact same issue that this court is facing today. The defendant is essentially inviting this court on appeal after having not objected to the missing strong R assessment at trial to elevate form over function in a situation where the strong R assessment likely wouldn't have helped him. And as a last reason as to why defendant hasn't established plain error review here, defendant didn't waive or he didn't show that he didn't waive this issue for tactical reasons, because again, this strong R assessment could have shown that he had a high risk of reoffending. So this case is about what is appropriate for this court to review, a court of appeals to review. And when a defendant hasn't properly raised this objection at his sentencing hearing and then presents it for the first time on appeal, he has to show that he's entitled to plain error relief. Defendant hasn't done so. And the state, therefore, respectfully requests that this court affirm the trial court's sentencing decision.
Ms. Wingberg? May I ask a question?
Of course.
With regard, I can't. I mean, but I'm just trying to be polite.
That was very gracious of you.
Happy to allow it, Your Honor.
I appreciate your consenting to a question. Okay, I'm sitting here looking, because I asked you earlier about under 40, 35, 207, and the 11 items that are on. And there's a provision in here that I've never, trial judge, saw or anybody's ever asked me about. But in subdivision C, it says in misdemeanor cases where the court has ordered a sentence, and cases which neither party asserts the existence of enhancement or mitigating factors, the court may direct the pre-sentence officer not to include certain types of information. So if neither party had filed, if I'm reading that, neither party had filed existence of enhancing or mitigating factors prior to the sentencing, then a judge tell the officer not to include certain information?
I don't think so. And I'm not looking at the exact section,
it's
but
a bit unfair to you not to be able to see.
no, that's okay. When I was reviewing this, when I looked at the statutory scheme, my understanding is that if the parties agree on certain aspects of the sentence, then that's the only time in a felony case that certain portions of the pre-sentence report may not need to be required. So if the parties agree on the length, for example, then we don't need enhancement and mitigating factors because the length is already determined. If we agree on the manner of service, then I'm probably arguing, well, I can't show any harm in the lack of a validated risk and needs assessment because I've already agreed I'm going to prison. But my understanding under the statutes is that the only time that portions of a pre-sentence report can be excluded in a felony case are when the parties have agreed on that specific portion of the sentence to be imposed. It's not left to the discretion of the court at a hearing. Excuse me. I want to.
Thank you.
Thank you, Your Honor.
Answer my question.
I would like to hopefully clarify a point that I tried to make earlier, and I don't think I did it very well. I think the state's argument about we have to show prejudice and we have to show what the strong R would have been, I think that is exactly why the Pace decision is wrong. Because we cannot ever show what it would have been because we cannot produce it. It has to be produced by the hearing. And the judge had said, I don't think we need that. I've got enough information here already. That strong R won't add anything in this case. If I then appeal that under plenary review, the state's going to argue, well, that may be error, but you can't show that it was harmful. And I still can't show that it's harmful, even under plenary review, because I can't generate that strong R. I can't generate a pre-sentence report. That is why it is statutorily mandated for the trial court to have it produced, for the trial court to consider it. Otherwise, if it is waivable, if it can never be plain error, if I can never prove prejudice even when it's preserved, then we have completely eliminated the shall in the statute. It means nothing. And I would ask this court to prevent any further erosion of the legislative mandates of what is required of trial courts to consider at sentencing. And we would ask you to reverse and remand for a new hearing so that the trial court consider everything it is required to have at sentencing. Thank you.
Thank you both.
Appreciate both the parties' arguments in this case. Will you call the next case, Madam Clerk?